So what is a will? A will is a document where you say who gets what and who is in charge of making that happen. Someone named in a will to receive your assets is called an heir or a beneficiary, and the person put in place to be in charge of making that happen is called a personal representative or an executor. It's important to note, though, that wills do not apply to assets where you have a surviving joint owner of that asset, or to assets where you have a living beneficiary designated. For example, on retirement accounts and life insurance, if you have a spouse named and then your children, then that asset will be payable directly to the living beneficiary who's named separate from what the will says. If you have a will, and a will is critically important for your estate plan, you need to make sure that it's in sync with everything jointly owned and also everything where you have a beneficiary name to make sure it all works together according to your wishes. Also, for any property passing under a will, it's important to note that that will has to be filed with the probate court and reviewed and approved before anyone in the will, the personal representative, can act on your behalf, can gather your assets, pay any creditors who might be owed money, and then ultimately distribute the assets to your heirs. A will is a document that does have to go through probate, which is actually a common myth we run across. People think that a will is a magical document that covers every estate planning scenario, and it doesn't. It's critical and you need it, but you need to make sure that you understand it goes through probate before it's effective. That's a will.